mean when we send our workers to the EU? What do I have to consider? So what's new? What has changed since the 31st of December last year? So as we know, the transition period has ended. We have left the EU. We're now a third country. There's a new deal, and the movement of people and single market access is affected. Single market, as most of us remember, is the market within the EU that essentially regulates the provision of services, which does include movement of people. We have left the single market, which broadly means we don't really have automatic access anymore. This means that we have to look at the trade agreement first before we even think about sending anyone. So UK companies, they will have to refer to the trade agreement to see if they can continue operating in EU countries as before. So in the trade agreement, it does include all the sectors. So don't worry, whatever you do will be in there, even if it's just general business. And under these sectors, each EU country or EU member state will have added a regulatory provision on how your company in your sector can operate in their country. So for example, if you're in the food industry sector, you'll go to that sector in the trade agreement and see if you can operate. And the way you do that is that you will look at the countries that have said, this is what you must do in order to operate here. And that's what you would do in terms of accessing the market in that country. If the countries you do wish to operate in or currently operate in do not have a regulatory provision in that sector, it's fair to assume you carry on as you are. But a word of warning, we would urge companies to check national websites under their trade and services section in any means first. So essentially, no automatic access to continue operating in the EU. Go for the trade agreement, find your sector, see if the countries you operate in have said if you need to do anything first. If you do not have a rule from a country, then presumably you'd carry on as you were, but do check the country's national website first, just in case, and then you can start thinking about sending your workers. So that's all new. Essentially, we've left the single market. Access is not automatic. You do need to check if you have the right to operate in that country. Go to the trade agreement, find your sector, and see which countries has said what you'd need to do, if any, to continue operating in that country. So what do you need to do? So when you find your sector, each activity in the sector is coded. So for example, if you find the sector for engineering and manufacturing, there'll be lots of different subsectors, such as sort of electrical engineering or civil engineering or whatever it will be, and they're all coded. And this categorizes your company's activities and will enable you to find the applicable rules. So not only is there a sector in the trade agreement, there will be codes for separate activities under that sector. And then you can go and look up your code on the WHO page, and you'll see what that code means, and then you can go back to the trade agreement and find where the applicable rules are. So each country will have different provisions. For example, France's will be different from Germany's, and so on. So just because France says you need to do something for your sector doesn't necessarily mean that Germany will say the same, and so on. Each UK company will then need to identify continued access to the single market before you even think about sending anyone to work in the EU, because you need authorization to operate in individual EU member states. Then you can send your workers. So within the trade agreement, there are other provisions, which I will go on to later in the webinar, including social security, essentially national insurance contributions, and worker definitions. Wish to flag that whilst it's a legally binding text, of course it is, there are some general caveats or exemptions in the trade agreement that clearly state individual member state rules take precedence if incompatible with the trade agreement. So what that means is that if you take Germany, for example, if their national law differs in terms of people to what the trade agreement says, then those German national laws will override what was in the trade agreement. So therefore, EU member states do not have to adopt all of the trade agreement. So there are some opt-out, opt-in sections of it. So whilst there are some definitions and provisions in the trade agreement, not all will necessarily be adopted by every single EU member state. So again, it really is down to what is a member state deciding to do? Which is very important to stop thinking of the EU as a bloc now. We've got to start thinking of the EU as traveling to America, and that the EU is not a bloc, and that we've got to take it by country basis. So we've got to come to the mindset that France is going to be very different from Germany, it's going to be very different from Italy, and so on. It's not a bloc anymore. Individual member states do differ quite substantially. So general exceptions, what I briefly referred to previously. So individual member state rules on working conditions, minimum wages, collective agreements continue to apply, and these override the trade agreement. So there is a section of the trade agreement that says everything contained within a collective agreement for that member state will take precedence. So collective agreements are pieces of legislation that bind employers in a certain sector. So there'll be different collective agreements for different sectors in different regions of each country. And within a collective agreement are all the rates of pay for employees in that sector, the working conditions, so working rights, holiday pay, overtime, and of course, the minimum wages. And that is also the local labour law, which we must comply with if we are to send workers to that country. So collective agreements override the trade agreement, that is made quite clear. So local labour law takes precedence. Unless otherwise stipulated, rules on entry and temporary stay of people continue to apply. So whichever the local immigration rules or each member state that they have, they continue to apply, unless otherwise stipulated, which we'll go on to in a minute. So within the trade agreement, each member state, and also the UK, can impose their own border control measures. And they also have the right to impose visa control on travellers unilaterally. Now, this doesn't mean everyone will need a visa. It just means that both the UK and the EU have the right to have their own border control requirements. So on entry, unilaterally, each country can have their own individual requirements on what they want travellers to present at the border, for example. And each country will reservedly have the right to impose, visa control on anyone they like. Now, it's not for everyone, but there is a right for each country to do that. So in the trade agreement, there are lots of definitions on what, for example, workers and businesses can do. But just remember, each country has the power to impose visa control and their own border control requirements. None of the rules on travel apply to public procurement. That's a different category. In some ways, if you are doing public procurement, the rules are actually slightly more complex, but we're not going to cover that today. We're going to talk about general UK-EU business commercial contracts and movement of people within our sector, not public procurement. Where there is a commercial contract in place between a UK entity and an EU entity, the applicable law that is applied is the place where the contract is signed. So for example, if you send a worker to sign a commercial contract in the Netherlands, Dutch law then applies to that contract. So you'll have to comply with the Dutch law in that place for the conditions of that contract. So, but in the other way around, if someone travels to the UK to sign a contract, then UK law applies. So that's also very important to note as well. So the trade deal, what does that mean on people? Movement of people. So unfortunately, the trade agreement does not make travel easier. Just because we've got a deal does not mean everything stays the same and everything is fine. By leaving, we cannot get a better deal. Business travel is already regulated within the EU. So that means other EU countries have to follow internal EU rules on their business travel, let alone us as a third country. Therefore, we cannot receive more favourable treatment than those EU rules. And if we use them as a benchmark, that is probably the most favourable treatment we can get, if not more onerous. So as I said, UK workers no longer have a right to work throughout the EU as they formerly did. We are a third country. We have left the single market. We have left the EU. We are completely separate. So we've got to get into that mindset. Again, UK workers can no longer travel to different member states in a single trip as they formerly did. I like to call this country hopping. So if you leave the UK, you go from France to Germany to Italy and then return. This is going to be very difficult. You'd have to require and obtain permission and authorization for each country. So EU travel regulations continue to apply. So they are individual member state national law. So an individual member state has their own travel regulations, they continue to apply. If UK workers are found to breach any of these rules, so individual member state national laws, they're effectively breaching the law, and the sending company, i.e. the UK, and your UK client, i.e. the receiving company, could be liable. So it's not just you who's sending the workers could be liable if your workers breach the rules, it's your client / customer who could be liable as well. So bear that in mind. So short-term business visitors. So these are people who are not undertaking remunerated employment. The trade agreement has provided a list of permitted activities that a short-term business visitor is permitted to do. However, yet again, they are subject to individual member state entry rules. So broadly, this is the list found within the trade agreement of activities a short-term business visitor can do, but bear in mind, this does not have to be adopted by a member state if they do not wish to. For example, if France has their own list of permitted activities for a short-term business visitor and it is not reflected in the trade agreement, then France may very well say our rules apply and take precedence. So this is just a start of 10. So broadly speaking, permitted activities for a short-term business visitor going to the EU include meetings and conferences, research and design, marketing research, training seminars, trade fairs and exhibitions, sales, but please note this does not include delivering goods or supplying services or direct sales to the general public that would be deemed as working, purchasing, after sales or after lease services in very limited circumstances, commercial transactions for senior personnel only. So you can already see between the lines, there are going to be a lot of limitations on these depending on the country you are traveling to. So as a short-term business visitor, most of you might be aware of this new 90-day rule. So essentially, as a short-term business visitor, i.e. someone who's not working but doing one of the activities listed above, you are allowed a 90-day stay in any 180-day period, which entitles you to visa-free entry. It does not, under any circumstances, allow the short-term business visitor to work. So entering for the 90 days just means you can turn up visa-free, but it does not mean you can work. This list, as I said, is subject to individual member state exemptions and their national law, whichever takes precedence. So take these with a pinch of salt. These broadly are what business visitors are allowed to do when they travel. However, individual member states may limit these. Workers. So workers is again quite broad, like a business visitor. However, the trade agreement has provided 4 different categories of worker. However, the rules around providing a service or working in general, so if you're working and don't fit into these categories, you are still deemed to be working. The EU will all be subject to individual member state rules. So whether you're providing a service, working in general, or doing any of the categories below, this is all going to be subject to individual member state rules, as can be found in the trade agreement. So business visitors for establishment purposes, contractual service suppliers, independent professionals, and intra-corporate transfers, ICTs. These are also known as secondments. I will go into those on the next slide. So all of the above will have different rules. For example, they will take into account the length of the worker's employment, their qualification, and the type of contract they're doing. So there are definitions for these categories, which I'll go into. You do have to meet the requirements to be categorized as them. If you're not going to fall into these buckets, you are still deemed to be providing a service or working in general that will likely require a work permit. So as I said at the bottom, in most cases, and we really do mean most cases, if the UK national is to undertake work, so remunerated employment, they are likely, very likely to require a work permit and or residence permit locally. The reason why I've included residence permit is that some EU member states issue work and residence permits together as a single permit. This is in addition to the advanced notification process and your compliance with local labour law. So not only if you are going to undertake work of any kind, you are most likely going to need a work permit and comply with their local labour law for the time you are there, even if it's just 1 day. So types of worker, as you saw on the previous slide, there are different requirements and definitions. So business visitor for establishment purposes. So this is only for senior personnel only, so senior management. This cannot be done by a junior employee. So senior personnel is allowed to enter an EU member state as a short-term business visitor for the sole purpose of establishing an enterprise. He cannot work. They cannot do anything other than that activity. So if you're going to establish an enterprise in an EU country, you can enter visa-free as a business visitor if you're going to do that sole task. If you're going to do other things in that same trip, then those will take precedence and you will probably need a work permit. But if you're going to the EU for that sole purpose, you can enter as a short-term business visitor to establish an enterprise. Contractual service supplier, something that we are all quite familiar with. So these are employees only. These do not include agency workers or self-employed workers. So if you use PSCs or freelancers or contractors, they cannot be included in this definition. If you use agency workers, they are not included in this definition. So contractual service supplier can only be for employees only. And this definition applies to those who are carrying out a service to the final consumer. The final consumer is the person who pays for this and receives it under a commercial contract. Now, the commercial contract has to be less than 12 months. And the worker, who is the contractual service supplier, must have had 3 years professional experience in his field, and he has to be with his current employer for at least a year. He also must have a qualification that reflects the level of their expertise. For example, it may be that for the engineering work, they might need level 4 HND, or if they need a degree, that is the relevant qualification. So they must have that as well. Independent professionals, this is going to be a huge barrier for a lot of companies. So if you are using contractors, self-employed personnel, personal service companies or freelancers, the trade agreement makes it quite clear that this group of people have absolutely no right to work or provide the service in the EU unless they are established in an EU state themselves, so they become a EU entity if you like, or they contract with a final consumer, which effectively would cut the middleman out of the picture. So if a contractor, PSC or self-employed person contracts with a final consumer, obviously they have the right to then do that, but they'd obviously have to get a work permit if they are working, or to get around this barrier, they can establish themselves in an EU state and trade as an EU entity. ICTs, as before, these are intra-company transfers, or as we call them, secondments. Essentially, the trade agreement provides lots of different definitions based on the seniority of the person and the length of service. So these definitions define the maximum length of the secondment. For example, the more junior you are as an ICT, the less time you have in the EU for your secondment. The more senior you are, the longer your maximum period of stay will be. So moving on to social security and non-compliance, just to note, this is completely separate to people obtaining access to the single market. This is completely separate from defining a worker and a category. Social security is the obligation to pay essentially national insurance in a country. It is very, very separate from who you are and what your rights are as a worker. So in the trade agreement, there is a big chapter on social security. As I said, this is a very separate chapter from workers and visitors and their applicable rules. So just separate what I've just said for a second and focus on their social security contributions. So as I said, really important to understand this chapter. It does not convey a right to travel and work. It simply defines the individual's social security status. Now, in general, there is an overriding rule in the trade agreement, and that remains the same. So essentially, anyone working in the EU is going to be subject to the individual member states' social security rules. which essentially means paying local national insurance for the time spent there. That is the overriding rule. As a rule of thumb, if you're going to work in the EU, for the time you're there, you should be paying local social security. However, there are some opt-in provisions. So the trade agreement provides a very broad definition of a worker who can work in an EU member state but pay social security in one state only. So this is sort of echoing the previous arrangement. So whilst we're an EU member state, there were rules around social security that essentially stated that you should only be paying social security in one state only, and you don't pay it twice, provided that the time spent abroad was for less than 24 months. And the way we did this was that every respectful country had a certificate to prove this. The UK calls our certificates A1 forms. Essentially what that did beforehand is that when you travelled abroad, you presented your A1 certificate, which declared that you were paying national insurance in the UK, and therefore you did not have to pay it in the EU. Now we're not an EU member state, those rules do not apply to us. However, what the trade agreement has done is essentially said, if you're a person who's going to go and work in an EU member state, and again, they've made that definition very broad, meaning most people can fit into that bucket, you know, agency worker, self-employed, general worker, business, whoever you are, you can fit into that definition. Essentially, they've got that definition to say, if you fit into this bucket, you can continue to pay social security in one state only, i.e. the UK. However, the EU member states have to opt into this provision. So there is this definition of the worker that says this type of worker can only pay national insurance in one state only if they make the definition, provided that the EU member states sign up to this rule. So these rules are an opt-in provision. So member states can choose to uphold this agreement, i.e. to pay social security in one country only rule, but they must imply that they will go to do this by the 1st of February. So at the moment, we don't know which EU member states are going to uphold this rule or not. However, even if member states declare that they are going to respect this rule by 1st of February, they can opt out of this rule at any time. So for example, France could say, yep, we will apply the rule that a worker will pay social security in one state only. Normally they're placed at residence, but 3 months later, France can say, no, we do not uphold this agreement anymore, and we will require that worker to pay local social security for the time we are here. So as I previously mentioned, HMRC issues our A1 forms. These are certificates that prove an individual paid UK national insurance. And if they're accepted in that EU member state, if that EU member state accepts that A1 form because they've opted in to this social security provision, then the individual is exempt from paying local social security for the time they are there. These forms must be obtained in advance, and they are needed in most cases per trip and per person. They are technically valid for 24 months, but an A1 form has got to have the exact dates of when you're going and the exact countries. So obviously you're going to need several if you are going frequently, because you'll need to update the dates and countries you travel to. But each person needs their own A1 form. So what happens if member states do not sign up to this provision? So essentially, where A1 forms are not accepted, or the EU member state has not opted into these rules, then unfortunately, that individual, whether it's a worker or self-employed or agency worker or whatever you like, that individual is liable to pay local social security for the time they are there. So at the moment, it's not clear which member states are going to opt into this rule, but we will know by the 1st of February. There is a statement in the trade agreement that says the European Union will notify the UK of which member states have agreed to uphold the social security rule. So penalties and liabilities, I briefly mentioned this before. So what are the consequences of non-compliance? So individual member state rules are legally binding. These are their national law. It's like the UK immigration rules. If you are found to breach these, it is seen to be breaking local law. Member states take this very, very seriously. And not only do they have their own individual immigration laws, they've got their own local labour laws, or all which must be upheld if you travel and work there. So if you do breach any of these, whether inadvertently or deliberately, you can be liable or penalised. So penalties, they do vary according to severity of breach. So if you've made an inadvertent error, the penalty will be substantially smaller. But if you've breached these rules deliberately and deliberately tried to avoid complying because it's difficult, then obviously the severity of the penalty will be much higher. So fines on average can range from 10,000 to 15,000 euros per worker. That's quite a common penalty. The sending employer can be taken to court. So if you've done something very wrong, like you've deliberately avoided these rules, or you've got your worker to lie at the border or something like that, then you can be taken to the local court there. The company / your worker can be banned from trading or entering that country altogether. These are obviously very extreme examples, but I did want to highlight how seriously EU member states take these rules. And also the liability for non-compliance will include the client / customer as well as the sending employer. So if you're a UK employer, you send a worker and they comply, then not only will you be liable, but your client customer may well be liable as well. Thus, you may be losing clients if you do this. So it's really important that you are aware of the rules, that you do comply, and that obviously the worker you're sending as well knows what they need to bring and do. Unfortunately, we do have case studies where a company was fined £32,000 for failing to make an application some months ago. This is while we were still in the EU, actually. As I said before, whilst as an EU member state, there were already rules that regulated business travel. And therefore, if we didn't comply back then, we were still fined. Now we're a third country, we have obviously different rules and we've got to do it on an individual basis, but those penalties and liabilities still stand. So not to scare everyone, but do take into account, we can be penalised and we can be liable if we are found to be breaking the local law or compliance. So professional qualifications, I briefly referred to this as part of one of the definitions in the trade agreement. So if you have a qualified worker where the qualification is directly relevant for their job or it's adhered to the trade agreement, it needs to be recognised by the EU. Just a note, if any of your workers have EU issued qualifications or EU recognised qualifications, for example, if it was gained in a European country at the time, or they've got a European degree, obviously that's automatically recognised by the EU because it's been issued by an EU country. But any qualifications that are issued by the UK, they're not going to be automatically recognised. So where the trade agreement stipulates that, for example, the contractual service supplier, in order to fit that category to provide that service, he needs a qualification relevant to his job. So that's going to be a degree. And if it was issued in the UK and he's going to Germany, he's going to need Germany to recognise his English degree. Or if he's got a technical qualification, again, that UK issued technical qualification has got to be recognised in the country they're travelling to. So the EU MRPQ no longer applies. This essentially means that UK qualifications are not automatically recognised in the EU anymore. So holders of UK qualifications, whether it's a degree or technical qualification, they will no longer be assured of their recognition. Previous recognitions may not be valid. So what I mean by previous recognitions is that if you went through an authorisation process before the end of the transition period, obviously you've gone through that process to have it validated by the EU. In some cases, that may not be valid anymore, but not that likely. Therefore, future recognitions will rely on each member state because each EU member state has different rules and each member state regulates industrial sectors differently. So if France recognises, your technical qualification, that does not automatically mean Germany will, and so on. So most of manufacturing, it is regulated in the member states, and manufacturing qualifications are both required and recognised differently locally. So one area of France could be completely different to another area in France. So this will need to be checked by individual member state national authorities. So you'll have to go to them directly to ask them to see whether your worker's qualification is going to be recognised in their country. So what you do, I've used Germany as an example, you'd contact the equivalent body in Germany describing the qualifications and ask them to go and compare them with the German equivalent, if you like. This process can be lengthy and costly. This is not an overnight process. It can take some time to have the qualifications recognised. And therefore, until the qualifications are recognised, your workers cannot go and work or provide a service in the EU until this is done. So obviously, as I said, if you're a tourist, this obviously doesn't apply. This validation process is only applicable where qualifications only need to be recognised or validated where the trading agreement requires it. So I gave the example of the contractual service supplier. If he wants to go and provide a service as per a commercial contract, he will need to have his qualification recognised. The trade agreement has provided a framework for future cooperation. So at some point in the future, there's going to be a joint EU-UK panel that will look at UK-EU qualifications. They haven't said when this will happen or when it's due to take place, but there is a framework in there that does commit to a future cooperation on this element because it is a slight barrier and it can cost a lot and take a lot of time. Finally, I'm going to wrap up with how we can help. So we've got a lot of support in this area. It's quite daunting. It's brand new. It's very overwhelming. There's a lot to get our heads around. We're in a different space now. So if you go to our website, the International Employment Support, we can help you with our services. So this includes bespoke and tailored consultancy. So whatever your company's requirements is, we can help deal with your issues personally. So this is not a broad package, one size fits all. This is completely tailored to individual businesses and their individual needs. Services include mapping the individual country requirements for our companies, the different types of permits their workers might need, the different local labour laws that might apply. Our services include navigating the trade agreement for you and its application. Where does it apply for you and your business, as it's quite a lengthy, complex piece of legal text. We also advise on how to provide services in each EU member state, which may be a barrier. And further consultancy service includes on how you can establish a new business, intellectual property, data protection, and contractual considerations, whereby if you've got a contract with a new entity, is it still valid? Does it still uphold anything said in the trade agreement? So we do provide support and help on all aspects on this area. So please do get in touch. We've got a big team of immigration and employment experts. You're about to hear from our top employment lawyer next, Lucy, and there's a number at the bottom there that you can call as well. Thank you very much.
Thanks very much, Alice. We're just going to move quickly on to a Q&A session because we've got quite a few questions here. So the first one says, regarding which law applies related to where the contract is signed, what if the contract is signed electronically from both locations, Alice?
That's quite a complex question. I'll have to go back to that at my own time. Normally, if that's an online procedure, again, that's an issue where it hasn't technically been signed in either place. I'd had to have more information on the context of that and then get back to them later.
Okay, we can pick that up afterwards. Aaron?
Next question. Alice, you mentioned that we cannot automatically country hop as it was before. Does that mean that an employee would need to return to the UK before going to another EU country?
Not necessarily. What it means is that you cannot almost breeze through different countries in the EU. You're going to have to get authorization and permission for each separate country. So if you are going to go from France to Germany to Italy, you're going to have to get a work permit for each country, comply with the local labour law for each country, and comply with the entry requirements for each country, which are quite hard to prove in one go. So essentially it's more work and preparation for that worker if they continue to do that. It's not impossible, but much harder.
Thank you.
So another one, would we be allowed to go to a country for a week to, for example, film a sporting event? Or is that considered working even if it's for a UK company?
So that sounds like working in general. So you may not fit into some of the buckets in the trade agreement, but because that's remunerated employment, you will most likely need a work permit to do that for that week.
Thanks, Alice.
Next question. Is it up to the individual employee to apply and obtain their A1 form, or could HR get this done for them?
Either really. There are two options. So an HR personnel could do it, or the employee themselves. However, depending on how many people require an A1 form, it may be more efficient if HR to do it, because HR have all the correct information at hand already, rather than giving the responsibility to the individual to fill in the A1 form correctly each time. So it's up to the individual company.
This one here around short-term business visitors. So this company has an apprenticeship exchange program with their Austrian sister company in place. 5 of their apprentices are staying in Austria for 4 weeks, and 5 Austrians are over in the UK at the plant in Sunderland. Would this fall under the training seminar exception, or would working visas be required?
Depends what the apprenticeships will be doing whilst they're there. If they're going to be taking on remunerated employment and working, then those rules will apply. If they're not working and they're receiving training at a seminar, then they can go as a business visitor. So in order to answer that question more in depth, I would need more information about exactly what they will be doing whilst they're there, because it all depends on that.
What about if it's just sort of practical training? So in a training centre, not just sitting in front of a screen seminar, but actually doing practical things, but not for remuneration.
So a lot of different member states have different rules on training. So some countries are very liberal, saying they will allow businesses to receive training. To deliver training is another thing. So normally delivering training is not allowed, but receiving training is. However, other member states, such as Austria, are very strict and wouldn't allow that as a business visitor. So my answer, unfortunately, is it depends on which member state it is.
Maybe combine 2 into 1 here, Alice, if possible. So the first part would be, where will we be able to find out what states will accept the A1 forms from the 1st of February? And then the second part, if I could possibly tie in, would be, how long should it take to apply for an A1 certificate start to finish?
Great question. So we've been given the deadline of the 1st of February. That's when the union will notify the UK which member states have signed up to those social security provisions. This will be a public announcement. So I presume it was going to be on the uk.gov website, or the news, or the respective member states' websites as well. What we will do, Make UK, we will send out a notice when this has happened and inform our members of which states have signed up. How long does it take to get an A1 form? Well, usually it should be, if you fill out the application, it should be back with you within 7 working days. There can be delays depending on the influx of applications. But before you apply for an A1 form, if you've never done that before, there is a notification form you as a company must fill to send to HMRC in the first place to notify HMRC, hello, I'm a company, I'm starting to send workers abroad now. Now that can take a little bit longer because they're registering your company on the system. But in terms of the waiting time for an A1 form, it should be 7 working days only.
Thank you.
As a contractual service supplier, would the employee need a Frontier Work Permit?
So Frontier workers are those that reside in one place permanently and go and work frequently in another country, but they return to their country residence each week. So Frontier workers, they have its own definition separate from contractual service supplier. So essentially you could be both depending on the nature of your task and the time spent abroad. Frontier worker permits are free to apply for generally and are a transitional provision. But they are valid for 5 years. But you have to meet the definition of the frontier worker, which again is going to be quite strict. So what you have to do is you have to prove that your work is genuine and effective. You can't be a frontier worker if your sole reason is going to be meetings and internal business. So more likely, you're going to be looking at the contractual service supplier requirements rather than the frontier worker permit, because essentially those are the people who are doing Monday to Friday in Germany and coming back to the UK every weekend. So you've got to look quite carefully about who you fit into there.
Thank you. Could a master shoemaker go to Paris to measure a consumer's foot for the creation of a last in order to allow the shoemaker's company to manufacture a bespoke shoe for that customer? It's specific, but
yeah, that's quite a specific question. I'll try and remember what that was. So if you're measuring that person's shoe and they're your customer, then that's going to be the final consumer, isn't it? You're doing work for your customer, that's working, you're literally providing a service to them by measuring their foot. If they're not the final consumer, then you may be able to do that as a business visitor, but it's unlikely you're going to be measuring anyone else's foot rather than the person who's going to buy that shoe.
right, thank you. Aaron?
My company is German owned, and we have an international cross-border. We have international cross-border functions, including sales. Can a UK-based sales rep visit a customer in Germany with a German colleague? Is this short-term business visitor, or are they working?
So two things. Broadly, any customer-facing work cannot be done as business visitor on both sides of the channel. So in the UK business visitor rules, which you'll hear from Lucy in a minute, if you come in as business visitor, you are not allowed to do customer-facing work. The same broadly applies if you're going to an EU member state. As a business visitor, you should not be doing any customer-facing work. Now, there may be some exceptions in terms of different countries and different activities. As a rule of thumb, you're not supposed to be meeting customers face-to-face or in any other relation whilst you're a business visitor.
I'm going to wrap up with two quick questions in one. One was, with the A1 form, does the individual employee apply for that, or does the company? And secondly, a company that has a division based in Poland that's currently managed by a UK paid employee, but he lives and works in Poland, does he need to apply for a work permit and resident status, and would he need an A1 form?
So if a UK national lives permanently or is permanently based in an EU country, they should apply for that respective EU member states settlement scheme. So like the UK's got an EU settlement scheme that tries to maintain the right to work and live for EU nationals in the UK, most member states have a similar scheme where EU nationals can sign up to maintain their right as UK national to live and work in that country. That would avoid you having to get all the paperwork. If you do not do that, then yes, most definitely, you will need to register your residence and get a work permit.
And just quickly on the, is it the individual or the company that applies for the A1 form?
It could be either, as I said. I would advise HR do it because they have the correct information at hand, rather than letting the worker do it on their own accord and putting the trust in them. Depends on how big or small your business is, but it can be done by either.
Lovely. Thank you very much, Alice. We're just going to pop up a few very, very quick polling questions just now. The technology decides to work, which will be really, really useful for our engagement with government. So if you're able to quickly answer these just now, we'd be immensely grateful to you. And we'll obviously share the results as part of your follow-up pack. Aaron, if you can tell me when we can move on.
People are still answering currently, so we may give them a couple more minutes before we then end the poll and then move on to the second part of the webinar.
Super, thanks.